So let's talk about this whole idea of kind of the integrity or the public perception of the court. I think one of the reasons why we're in this situation is because we've had too many justices that essentially conducted themselves like activists on the court rather than judges. Because when it comes to a judge, especially a judge with respect to the Supreme Court, the function is to determine whether or not a law violates the Constitution. That's your job. Your job is to determine. Now, this law could be super duper popular, but if it violates the Constitution, then it violates the Constitution. And presumably, your job as a justice on the Supreme Court is to say this violates the Constitution, and so you can't enforce this, you can't enact this, or this law is null and void. That is what a justice on the Supreme Court should be doing. Now, if justices had actually consistently over time behaved that way, and they can even write it into their opinions, they can even say, I actually think this law might be a good thing, but it violates this portion of the Constitution, and therefore it can't go into effect unless you amend the Constitution. That would give a justice the ability to explain that I'm not prejudiced, I'm not supportive, I'm not pro or con for this particular law or its implementation. I'm just saying that it violates this section within the Constitution, so it can't be effective. If that had been consistent with our justices, then I think people would be able to look at that and say, like, okay, I may not like the result, I may like the result, but either way, I understand the reasoning, because the court is not there to pass judgment on whether or not a particular law is a good idea or a bad idea. This is one of the things that so many people, I think, misunderstand about the Supreme Court. Because when they hear justice, and especially now because the term justice has been so perverted within political discourse, that the idea is justice is what you think is a good thing, right? Justice is the outcome you want, that you believe is the best, right? A Supreme Court justice is there to determine whether or not a law has followed the constitutional process and been enacted, and whether or not it violates the Constitution, usually whether or not it violates some sort of civil liberty. Okay, that is what they're doing. So justice is not this idea that every individual might have in their head with respect to the outcome they prefer. Justice within a legal system is a question of whether or not, from a judge's perspective, on whether or not the proper processes have been followed and whether or not a law has violated the Constitution. Now, this part is going to blow some people's minds. What this means is that the Supreme Court can decide that something is unconstitutional, and they can overturn a law. And in the process of overturning that law, it can actually produce a result that nobody prefers and that nobody likes, but it would still be a good decision, because we're either a nation of laws or we're not. We're either a nation that understands that before we use the power of government to compel somebody else to do what we want, or deprive somebody of life, liberty, or process, there are processes that have to be followed. And when they are followed, that is, on some level, that is a just process. And when they are not followed, that is unjust, even if you might like the particular outcome. Because there's essentially two ways that we achieve justice, and this is very important to understand. From the legislative side, we're trying to achieve justice by writing the law in such a way that actually produces just outcomes. What the court is trying to do is determine on whether or not those laws were written in a just fashion, which is to say, did it follow the legal processes in order to be enacted, or did it violate those legal processes or the Constitution in the process, right? But if justices just decide that their job is to take a public opinion poll and decide what they think is best, as a result of that, we don't have justice. That is not, even if you like the particular outcome, that is not a justice system that you want to live under. Let me explain why, because I'm willing to bet nobody here would want to be on trial for their life. Nobody here would want to be on trial in a way that could lock them away forever and have a judge or a jury making a decision not based off of the facts of a case, or in this case, not making the decision based off of the clear reading of the Constitution, but doing it based off of their perception of its popularity. That is not a just system. And what drives me nuts about Sotomayor's comment here, this whole idea, will the Institute survive the stench that this creates in public perception? The stench that I have right now with respect to some of the members of this Supreme Court is the idea that they don't feel themselves bound by any sort of intellectually consistent judicial philosophy other than if they like it, then the answer is yes, and if they don't like it, the answer is no. That is what is causing so many people to lose faith within our justice system. So that is one of the, and I got to hand it to the Mississippi Solicitor General, Scott Stewart, because he said the court could say now that their legitimacy, because they were talking about previous decisions and public opinion. He goes, the court could say now that their legitimacy comes from standing on constitutional principles and overruling when appropriate. What a novel idea. Because I got news for Sotomayor. She may like this idea of popular opinion, or again, her perception of popular opinion, deciding what a Supreme Court ruling should be. But there are other cases in U.S. history where the Supreme Court might have made a decision that could have been popular, or could have been popular in the minds of the justices that made the decision, which were complete violations of the Constitution. I'm thinking of things like, the Dred Scott decision. So this should be a fairly simple standard, and that's not to say that reasonable people cannot agree or disagree on what the Constitution says in a particular case. But the idea that public perception is the primary concern of our justices, holy crap, we're in danger. All right, let's look at this. So one of the questions that came up with this, and this has to do with, you have Roe v. Wade, but then you also have the Casey decision, right? Casey versus Planned Parenthood. And all Casey really did was it created this structure within Roe v. Wade and abortion law where, again, you have that line of viability, which is, again, you can have more abortion restrictions after the line of viability than you can before the line of viability. And then the other one was this undue burden standard, right? And if you really want to see a good takedown of the whole undue burden standard, go look at Justice Scalia's comments on this. Because Stewart, the Mississippi Solicitor General, described it. He goes, the decision that went into the undue burden standard, which Stewart called the most unworkable legal standard in history. And it is, because I want you to think about this for a second. This is one of those times where, I've said this before on the House floor, other of my colleagues have said it too, because we don't write intentions, we write laws, right? So it's very, very important that we write those laws in such a way that they make sense and they're easy to interpret, and we take into account second and third order effects and unintended consequences and all that, right? By coming up with this undue burden standard, it's now kind of subjective. Like, how do you write the law in order to determine what an undue burden is? Like, so for instance, some states said, hey, before you get an abortion, you have to get an ultrasound. All right, is that an undue burden? Is it not an undue burden? Right, it ends up being this thing where judges just kind of decide, right? It's really, really hard to write a law on that to determine what constitutes an undue burden, right? So one of the things they were talking about was that is actually becoming a real problem with respect to how legislators handle this issue. He goes, this is another important point, and this has to go with the whole line of viability as well. He goes, Stewart then added that Casey did not take into account advancement in medical knowledge. When asked what advancements had taken place since Casey, he pointed to studies on fetal pain, which Sotomayor dismissed as being from a small fringe of doctors and not a sign of an actual advancement of knowledge. She noted that brain-dead people have responded to stimuli, so a fetal response does not necessarily mean anything. Wow. So let me get this straight, because I'm always curious on where the threshold is with respect to following the science. And I'm especially curious on where the threshold comes with following the science when we're talking about destroying human life, right? So Sotomayor is saying that, yeah, there's these studies, but she considers them a small fringe of doctors. Again, I don't know what further justification she gave for that. And she said that brain-dead people have responded to stimuli, so a fetal response does not necessarily mean anything. Okay, that's a pretty bold statement when we're talking about actively destroying human life. And there's going to be some people that take issue with me calling it human life. I'm going to explain later why I use that terminology, and I'm going to do so using science, all right? But again, I find that interesting. Because there's another element in here. This goes to the whole viability line. Stewart said it was quintessentially legislative. He later argued that the line discounts the state interest in protecting human life. Justice Elena Kagan questioned whether his viewpoint on when life begins is a religious one. Stewart insisted that it is not, and that regardless of when life begins, it is still a human organism involved. Okay, now let's look at this real quick, because I find this interesting that Elena Kagan would immediately go to this idea of, is your belief in this a religious one? I am curious if she would have asked a similar question in another case of someone that was of a different faith. I'm very curious on whether or not she would have done that. Maybe she would have. I don't know. But let's look at this. But it's interesting because Stewart insisted that it's not. He goes, regardless of when life begins, it's still a human organism. Here's what I find interesting. This whole question of when life begins was not something that we found all that difficult when we're talking about an organism other than human life. It just isn't. If you go look at biology textbooks, if you go look at the various medical standards that have been used to distinguish between a living entity or a non-living entity, it hasn't been all that difficult. Now, they may categorize life on different levels. You can have sentient life, you can have intelligent life, you can have non-intelligent life. Congress proves that you can have non-intelligent life. But the point is, all right, is that you can have different categorizations within life, but the whole idea of life generally falls within a variety of characteristics. And those characteristics include things like the potential for reproductive capacity, homeostasis, the ability to turn food or some other sort of thing into energy, growth, right? These are all things which suggest or differentiates between a non-living entity and a living entity, right? And generally speaking, the way we've always looked at this is that if you meet these criteria, for some standards, you only got to meet some criteria. For other standards, you got to meet more of those criteria. But if you meet them, then you're considered a living entity. Right? Now, guess what? At the moment of conception, you meet all of the standards necessary to be designated a living entity. There's not a single scientist around the world that would find something as complex as a human embryo or even a zygote in a different part of the world and not come to the conclusion, oh my gosh, that's a living entity. But somehow we're supposed to suspend reality when it comes to this issue, not because the science justifies that sort of position, but because a lot of people really want a particular outcome. And if science and if scientific definitions and understanding has to suffer in order to give people an outcome they desire, well then I guess that's how we're going to write the law now. So first things first, when you look at the criteria we use to distinguish between life and non-life, at the moment of conception, it meets all the definition for a living entity. All right, so I haven't said human yet, living entity. Now here's the next question. How do we distinguish between living entities? Because obviously we don't afford the same legal protections to a dog that we do to a human being. So gosh, what sort of scientific mechanism could we use to distinguish between living entities? There's a number of characteristics. Obviously, human beings have certain characteristics that are unique to human beings, or the composition or the order of those characteristics are unique to human beings. So yes, a dog can have 4 limbs, a person can have 4 limbs. But there's obviously differences in the characteristics between the dog's limbs and the human's limbs, and we use that in order to distinguish between the two. This is basic science. But let's go with something a little bit more concrete, since now that we've mapped the human genome. All right? How about deoxyribonucleic acid, DNA? At the moment of conception, you possess all of your DNA. And that DNA is uniquely yours. Okay, that speaks to the autonomy and the individuality component, and it is uniquely human. There is nothing in that DNA that is going to suddenly shift and cause mom to pop out a giraffe. That's not going to happen. You're going to be a human being. So at the moment of conception, you meet the scientific criteria for being living, you meet the scientific criteria for being human. Now the third question, which doesn't come up here, but which I think is important, is do you meet the legal definition of innocent? And I would challenge anybody on the left to tell me that human being at that moment in time doesn't meet the legal definition of being innocent.